SJC-13633, Commonwealth v. Dharmal E. Safi.
Okay, Attorney Schnipper. Good morning.
Good morning, Chief Justice Spud, and may it please the court. I'm Merritt Schnipper representing Dharmal Safi today. Simply as a question of fact, the mandated report made by Clinical and Support Options to the Department of Children and Families establishes that AR spoke with her therapist about this alleged assault.
Can I get into the factual independence for that?
Sure.
To quote Ronald Reagan about trusting and verifying.
I mean,
So-
that's one that stood the test of time for sure.
Right. So I read your affidavit on your third paragraph, and the last line of the third paragraph is the DCF report describes Saperstein as telling a DCF investigator, and it quotes language. I assume you're referring to the clinician's 51B report.
So there's two things going. There's two affidavits in play, right? There's counsel's affidavit. I'm not trial counsel, so
Right, no, I know,
Right.
right.
So my affidavit was proffered to the single justice for the limited purposes that I discussed in my reply brief. I can go into them here, but what I'm really talking about is the recitation by counsel in the Dwyer motion itself that Clinical and Support Options conducted this crisis evaluation and then reported to DCF in the wake of that. So I think it's a plain inference from the fact that you have a minor child alleging sexual assault.
Okay, but what I'm trying to get is the underpinnings of that. So I get from the Commonwealth, the CSO clinicians 51B, and it seems like we don't have all of it, but I look through that and I don't see the child reporting this sexual assault in that. I have mother says,
Well-
and I have she participated in the same, but those are two
I guess
very
I'm
different
not
things.
sure I understand the question, because obviously a 51B happens when a 51A happens.
Right. But the question is, there's a supposition that, and you do a great job on your brief saying this is what 51A requires, and you can infer based upon this that she described the assault. But when I look for the factual underpinnings of that in the 51B, I don't get it, and I'm just wondering if I'm missing something.
I don't think you're missing something, and I don't
Okay.
think the 51B is tendered to the court in the context of the Dwyer motions. It's really just counsel's affidavits and the motions himself, and the motions, of course, are just a set of factual allegations. They're not a set forth
Right,
of
but
legal
you
argument.
have quotation marks in your affidavit, and I'm just wondering, what are you quoting from?
What I'm quoting from is the discovery, and I'm quoting from that for the purpose of saying to the single justice, no, you should not dismiss these motions with prejudice in the event that you vacate the Superior Court
Okay,
orders. And the
and
reason
when you
you
say
shouldn't do that is that the actual discovery that the Commonwealth provided
Right, when you
shows that there
okay.
was all this stuff going on.
All right, so we're probably talking past each other. When you say you're quoting from the discovery, what discovery?
DCF reports, right.
Okay, that we don't have.
Police reports. The court does not have before it. I mean,
Okay.
except what the Commonwealth chose to put in its supplemental appendix. But what I think is really important here, right, is that what we have, based on what the facts that are alleged by trial counsel in his Dwyer motion, are facts sufficient to support a finding that this minor reported the alleged. First, she goes to an emergency psychiatric intervention, which is where the initial report of sexual assault occurs. Then we go to the Clinical and Support Options crisis evaluation. That's the one that results in the report to DCF, and from there directly to 2 weeks of inpatient therapy. So what we have are a set of facts sufficient to demonstrate not only that there was an initial report, in other words, a conversation between this minor alleging sexual assault and a therapist, which of course is sufficient to entitle a defendant to summons records under the first stage of Dwyer under the court's case law. But then we have the necessary operation of statute that report to DCF in the case of a minor will be channeled directly into the investigative and prosecutorial function. And that direct channeling, so in other words, from initial complaint to therapist to district attorneys and police being informed immediately, the statute says the word immediately means we are beginning the process of a criminal investigation and prosecution. And once that process begins, we know that the defendant has rights to the exculpatory or potentially exculpatory statements of the alleged victim that are contained in these treatment records.
If we take a step back and look at what was in front of the single justice, he had to make a decision about Judge McDonough's decision, right?
Yes.
Which did not include this 51A theory, let's call it.
No, it did not, and I accept that a better practice would have been to fully enunciate it there. I think we're in an unusual posture in a Dwyer case.
And then we have the single justice at the end saying, well, you could refile.
And in the event that this court affirms his judgment, that's what will happen, and that's, I think, one of the reasons that it's worth.
Yeah, right, you anticipate the question, of course, is why reach it here when we're deciding whether or not the single justice abused his discretion?
That's a completely legitimate question, and I think
you.
there's, and I think you got a lot of them, and I think there's two good answers for me to provide. The first is that this is a very unusual Dwyer case because we're not reaching the court after a trial conviction in which a defendant is saying, my Dwyer motion was improperly denied, and the court would appropriately say, you're not going to enunciate any arguments that you didn't bring to the trial judge. We're in an interlocutory posture where the motion, of course, was allowed in the Superior Court such that an appellate court can affirm on any basis apparent in the record.
And maybe the point of me asking the first question is about the basis of what you said. If we were to say that you have that option that Justice Georges gave you, trial counsel would go back to the judge, have an affidavit that quotes from the discovery and lays it out for the judge, which we could review, correct?
That would certainly happen, and I can tell you what will happen. I'll insist that not only the facts laid out in the DCF discovery be more effectively presented to the trial judge, but that my argument about the structure of the statute also be included in a written argument that's submitted with that motion. And of course, we could give Judge McDonough the first pass on that, and because he allowed these Dwyer motions without that argument, and this argument would make these motions much, much stronger, presumably he would allow them again. We might then face another 211-3 based on the policy arguments we're facing now, and we could come right back to the single justice and then theoretically to this court as well. But we're 4 years out from indictment in a case that is getting a lot of age to it. So this issue is, I think, of significant importance, not only to this case, but to many child sex offense cases and in just the ongoing balancing of Dwyer versus constitutional rights to present a defense. And I think it's fully presented for the court and appropriate to decide now. And I do think that there's an interesting, and it's hard to believe, not previously explored issue. It's not an issue, but it's an interesting balance that when we look at the tools we have for legislative interpretation, like, you know, the legislature set up a protective confidentiality and privilege system, and then it basically made 51A and 51B a relatively significant carve-out to that system, or not necessarily even a carve-out, but something that works in conjunction with it to say that when we have minors reporting sexual assaults, we are downgrading the priority that we place on confidentiality and privilege to the extent that we are going to require that those allegations be basically, though they go through DCF, they're directly reported to the police and the prosecutor's office for purposes of investigation. And that's a completely legitimate call for the legislature to make, that this is what we prioritize, investigating these alleged crimes against children, which are so serious. But any time the legislature makes that sort of prioritization, it's bringing with it in its decisional train all the constitutional criminal procedure rights that the defendant has.
So your position is the fact of a 51A report would mandate disclosure?
I think it gives a defendant the basis to satisfy Dwyer.
Well, here's the point, though. It doesn't mean that the child discussed the substance of the allegations with a therapist, correct?
Well, it means at the very least that the information that's required by 51A to be contained in the report is transmitted.
But it could also be that the mother was negligent or neglectful.
It theoretically could be, but one of the reasons there's such a strong...
Which is what happened in this case, too, right?
It could, but what's happening here is that we have a child who's already enmeshed in the mental health system and has a bunch of pre-existing conditions, who then comes, and what we know from the facts laid out by counsel in his affidavit in motion is that she runs away, says she's going to think about committing suicide. She's running away from home. She's recovered, brought immediately to emergency psychiatric care where an allegation of rape is made. So it's certainly quite possible that mom could be found negligent through a DCF investigation. But these facts, the timing of the clinical and support options mandated report strongly suggests, and of course we all know that we have to make Dwyer showings without having seen the records, strongly supports the factual inference that this was a discussion of a sexual assault.
Right, and that's really the linchpin, is whether there was discussion of the sexual assault.
Absolutely.
To mine for inconsistent statements or consistent statements, correct?
I agree with that.
All right. That has to be shown through the 51B, right?
Well, I just think that the fact that because again, what's the stage of the prosecution? There's been an indictment. We're in the criminal process. So obviously,
But like in this case, you have a 51B that says something, you have a SANE interview, you get all the SANE tapes, or if there's still tapes, you get all the SANE information, right?
Sure.
And you get the police reports. So you have a basis.
But there's a significant amount of information that's already been provided.
Right.
Right, but that doesn't really get to the question. And one of the things that's so, I think, crucial about this case, and this places it in contrast to the mine run of cases where we talk about, you're not just entitled to Dwyer material simply because someone alleges sexual assault and then is referred to a therapist. This isn't a referral to a therapist. This is a journey into custodial mental health care for the 2 weeks following your initial report, which means, and of course, this is a case in which the only defense is fabrication. That means that demeanor and state of mind evidence related to whether an alleged victim may be fabricating, may not be fabricating. The Commonwealth presumably will seek to introduce evidence of her distress and mental health issues in the immediate aftermath to show that her complaint is legitimate. That's a legitimate use under this court's case law of that behavioral evidence. But the defendant is also entitled to challenge the allegations on the basis of fabrication, and that is going to be based on demeanor and state of mind that is reflected primarily in the way she's discussing the alleged assault. And the only evidence of these discussions is going to be contained, it will have been produced during this period of therapeutic custodial care. So there really isn't any other, so I think that makes us much stronger.
But you have to get beyond the case law that says that the mere fact of treatment doesn't satisfy Dwyer-Lampron, correct?
That's right, and I think we are well beyond that, because not only of the time period in which custodial treatment is occurring, but we have the fact that we have a transmission from a mandated reporter directly to the police and prosecutors that's resulted in an indictment.
Is your position different for any of the four providers?
It definitely is the same for the first three, meaning the Cooley-Dickinson emergency.
But Cooley, was there a 51A?
No, there wasn't. So perhaps then they're out. But on the other hand, that is the context in which the initial report occurs. And it's also not in any way clear just how fast and what the connection is between Cooley-Dickinson and CSO. So CSO and Cooley-Dickinson, those are physically located very close to each other. And then, so how fast a person goes from one to the other, what I think is interesting is that there is no mandated report recited from Cambridge Hospital, but that's where she goes immediately for the treatment that results from the mandated report.
So it's the first two 51A reports are filed.
But the last 51A is actually from the Northeast Center for Children and
Right,
Families,
so the
which
only
is the
51,
therapy
the only
provider.
51As are by CSO and Northeast.
That's
right?
correct.
Okay, and so to me, that might put those two in a different position, although the Northeast request is entirely too broad. Would you agree with that?
Broad, but I think that some period predating the allegations is appropriate, because I think a substantial issue at this trial is going to be whether these allegations are themselves manifestations of pre-existing conditions, because of course counsel does recite 2 other crisis events in the preceding year, and that's, so I mean, if you want to go 6 months back, I think it's appropriate to go some amount of time back so that you contextualize the mandated report treatment that produces that to
So
what was
6
going on
months
before.
back for Northeast.
I mean, I think that's fair.
Okay, and then not Cambridge Hospital, because there's no 51A from them. CSO, yes, because there is a 51A, and not Cooley.
Well, I don't think it's appropriate, frankly, to treat Cambridge Hospital and CSO as completely separate, because what happens is there's the crisis evaluation and the transmittal, so there very well may be, basically, it's one 51A.
But where's the evidence she made statements in the initial crisis?
It's the fact that it was reported to DCF. So, I mean,
By
but I also think
CSO.
CSO.
All right, so baby steps, right? CSO actually did a 51A, and Northeast actually did a 51A, and you want 6 months back.
there's certainly nothing wrong with saying those are appropriately granted, take a look at those, go back to the court and make a second showing. I mean, that is fine. And I think one thing that, because going back.
I'm confused. 6 months is just plucked out of the air, because I mean, the trial judge allows from January 2019 to December 2020, the end of December 2021. Why would 6 months be legitimate?
Because there's a period of a year that's described, a year preceding this alleged assault that's described in counsel's affidavit that basically says during this period she was dealing with all these other behavioral and mental health issues, and there were 2 other crisis events. So I think it's an important consideration for the defense whether the behavior that, and we don't actually know whether those crisis events were related to allegations of sexual assault right now or not, but assuming that they may have been, what we want to know is were there prior allegations that were unsubstantiated? Is there a basis for claiming fabrication in these records? So there's some amount of time in the mental health context preceding the allegations, I think that's appropriate.
Counsel, isn't that pretty close to just speculation on the fact of receiving mental health care equals evidence?
I don't think it is when you're in a situation where like the mental health distress is such a part of the situation in which the allegations
I
arose
understand
in the
that,
first
I
instance.
understand that argument with respect to the incidents that we're talking about, the incidents at issue here, but I'm talking about the 2 crises that were in the past. Is there anything beyond sheer speculation that those may have had to do with some other allegation by this victim?
Well, the only thing that's beyond sheer speculation is that the victim's mother says, according to counsel's affidavit, the victim's mother attributes the runaway and suicidal ideation to all these other.
No, she specifically attributed it to her premenstrual dysphoric disorder, which has nothing to do with allegations of sexual abuse.
Well, I'm not suggesting they do, but what I'm saying is that the initial concern is that all this behavioral stuff is related to something else other than a sexual assault, right? So it's quite possible that that's the case, right? That's quite possible that that's the basis of a defense. And the only way to understand that is to contextualize that with some access to the records from that provider. I do want to, I see I'm over time, but I do want to quickly make the point that a finding that a 51A to a 51B to an indictment basically satisfies the requirement for a summons under Dwyer is not some sort of massive setting aside of legislative priorities of confidentiality and privilege for 2 reasons. One, obviously the legislature more or less intended it, but second, this entire case has been argued by both sides, frankly, except I'm a little bit less responsible for this, on Lampron grounds. But there's Dwyer, right? There's a stringent and quite threatening protective order that counsel has to sign before counsel can go into a room all by him or herself and look at these records, right? And if you mess around under the terms of that protective order, you're reported for bar discipline, and you also, of course, have your underlying ethical obligations to think about. 2 additional judicial findings in the Superior Court are required before there's even a possibility that these materials can be used at trial. Those are meaningful and substantial protections for confidentiality and privilege purposes. And the fact is that if the defendant fails to show relevance, it's over. If the defendant satisfies relevance, it's one of multiple steps that might end up with trial use of these materials. And I do think that's important when the court thinks about how Dwyer plays out in the Superior Court, because the defendant's leaning on constitutional rights here, and the fact that these protections don't end upon a showing of relevance, I just think favors summonsing them and then letting a Superior Court judge who deals with these every day say, okay, counsel, you've had a look. Now, do you have a showing to make about trial use or not? And I mean, that is the protection that the court has imposed for purposes of privileged records, right? Lampron applies to anything, I mean, a negligence suit related to premises liability by a third-party contractor, right? You don't have the privilege mechanisms there, but you have the same 17A2 showing.
Do you have a proposed definition or understanding of the term evidentiary in the phrase evidentiary and relevant?
Sure. I mean, availability for use at trial. I mean, as the Superior Court judge says, these are medical records that generally are admissible. Obviously, statements of an alleged victim about a crime are admissible largely as of right, at least for impeachment purposes. And you have records that are very highly likely to contain demeanor evidence. It's going to be highly relevant to a showing of potential fabrication. So I think all those make them both evidentiary and relevant.
It's not just admissible. It's not just admissibility.
Well, I mean, I think evidentiary and relevant kind of, when you add those together, you get admissibility.
Okay, thank you.
Thank you very much.
Attorney Frosto.
Chief Justice and Associate Justices, may it please the court. My name is Asrat Frausto, and together with my colleagues, Matthew Knowles and David Gayshok. I represent AR, the victim in this case, and there are two things that we're asking the court to do here today to preserve the delicate balance that the court set when it established Lampron-Dwyer. The first is to affirm Justice George's ruling. Here, there's no dispute that the motion that Safi filed before the Superior Court was deficient. You heard Safi's counsel, he does not defend those motions based on the record he presented to the Superior Court, nor does he defend the Superior Court's reasoning, so affirming Justice George's here is easy and straightforward to do. The second thing, Your Honor, is when affirming Justice George's decision, the court should explicitly reject Safi's troubling argument that the mere statement of a sexual assault to a mental health provider in a Section 51A report is sufficient reason alone to allow records to become accessible under Lampron-Dwyer. It is imperative that the court reject this argument, as it is not supported under this court's case law, and if the opposite were true, it would mean that no child would ever have access to confidential treatment after being raped.
Does our case law says, or does it say, that if psychiatric records or therapeutic records include a description of the assault, sexual assault by the victim, then that is grounds for relevance and admissibility, correct?
I think
Or it satisfies Rule 17?
I actually think that what the case law says is that it requires more than just the mere statement. And I have two examples on this. So Labrador, for example, is one instance in which the court has allowed defendants to access those records. In Labrador, just for quick context there, the defendant sought to seek a broad set of records, as defendant is seeking here. And when the Superior Court denied it, and then there was trial and he was convicted, he filed a motion after trial with the appeals court, saying that essentially just because there was a statement that the victim had made to a psychologist, that was sufficient of a reason to allow the records to come in. The appeals court said the mere fact that a statement exists is not sufficient reason. So what the defendant did there when filing his brief before this full court was to actually narrow the set of documents and include allegations of all the inconsistencies that the victim had previously done in that case. And that is the only reason that the court allowed those records to come in, because of inconsistencies.
But let me ask, because that was what caused Lampron and Dwyer. Under the Stockhammer-Bishop protocol, judges would get records, and they would say, complainant said A, B, and C, and then the judge would say, well, I don't know what's out there, because I don't know it's consistent, inconsistent. It's just an impossible task. That made us move to Lampron-Dwyer, where the defense attorneys could articulate better the need for records or what the universe of records is. So you're trying to take us back to Stockhammer-Bishop by that, right?
I'm not, Justice Graziano, and here's why. So here, it's not, first of all, this is not an impossible standard to be met. As I mentioned, Labrador came after Lampron-Dwyer, and there are instances in which defendants can establish a showing to access records. This is just not that case, and here's why. We do actually know what my client has said. So as Safi's counsel noted, the 51A reports require a broad array of information. It requires that the mandated reporter indicate the identification of who caused the rape, identify the circumstances under which the rape occurred. And here, if you look at the 51A report, it actually shows the opposite of what Safi is seeking to show here. It shows that my client has been entirely credible, because in the mandated report, it indicates that she met him on September 4th, that he took her to 2 different locations, that they met on Snapchat and communicated via there, that he raped her, and then when she disclosed this to her friends, she indicated that her friends said that they had the same experience with him. So this is not a mistaken identity issue or an issue in which my client has invented things or recanted things.
That's for the trial. That's the ultimate call. Don't we? Are there cases? Again, I'm not as familiar with this area as some of my other colleagues. Are there cases in which we have a 51A, 51B report of an assault where it wasn't allowed to be turned over, that particular part of it? I understand it can include, like this, all kinds of stuff that's obviously should not have been turned over and is not eligible for. But have we said in cases that if you have a 51A, 51B report that reports the assault, the sexual assault, that doesn't go to counsel?
So, Your Honor, this
Any case?
you actually have not evaluated this question before, and that is why Safi presented this as issue 1 in his appellate brief. He's asking the court to weigh in on this issue. And so there hasn't been that discussion before, but in Commonwealth v. Jones, one of the issues that the defendant there was seeking records from was actually based on a DCF report that one of his daughters made, stating that she only remembered one incident in which her father abused her. And the defendant was saying that that was alone of a reason for him to access those records. But this court said, and this was again under Lampron-Dwyer standard, that it was entirely speculative and that he wasn't showing a particular allegation, which is the same instance here.
Yeah, I think you're going to have to come to terms with the harder question.
Yes.
Justice George, there's not going to be an abuse of discretion given the breadth of this and the lack of analysis by the trial judge. But we have more difficult questions to answer, right? Help us out here. When we have reports, can we really exclude them? I mean, I'm just trying to understand, because we can't make the ultimate credibility finding that you want us to do at this stage. Particularly, the defense counsel doesn't know what they said.
Your Honor, so 2 things to that point. We're not excluding the 51A reports. He has access to them. We're just excluding the 4 mental health records that he's seeking on the basis of those of Section 51A report. So this is just like any other request for
The statements within that aspect of it within the counsel.
So the statements within there, Justice Kafker, they don't indicate that there would actually be anything exculpatory there for the defendant. And at the end of the day, what is required to establish...
I guess we don't know. That's the problem. And actually, one of the problems, that's why I asked counsel about this, is we don't know what you folks have the records. You have the 51Vs. You have the police reports. We're getting snippets of things and asked to draw, conclusions that will affect many, many, many cases, which I think counsels for taking this in baby steps as opposed to making broad proclamations about the 51A value. What's your position? I think you started out that we shouldn't decide this 51A issue because it wasn't raised below.
So what we're asking the court to do here today is to allow the Justice George decision to affirm it and to allow Safi to file a new motion. But in so doing, clarifying that the argument he has raised before the court today is not sufficient. That's simply because a Section 51A exists and there's a mere statement to a mental health provider of the sexual assault. That is not alone sufficient of a reason under this court's case law. They have to show more. And here, as Safi has stated, there is a strict liability case. The only defense that he has is that my client fabricated, as is mentioned.
Well, here's the problem. If we have, the government may have a very strong case. They may have Snapchats that show everything, GPS. I have no idea. Again, we're in the dark. But if the complainant says that we met at the high school, and forgive me, I don't know the facts as well as you do, but the complainant says we met at the high school and then went to the McDonald's. And then there's a 51A therapist report that says they met at the town library, then they went to Wendy's. That's relevant, and that would be admissible at trial, and that would be an inconsistent statement, correct? It could show fabrication.
Under that hypothetical, yes, Your Honor, but here, again, there's no indication of that. And
But
again,
we don't know. That's the problem we
well,
have.
Justice Graziano, what I would say to this is that we do know what could be in the statements because the 51A reports already require lots of information to be included there. So we actually do know what...
Which doesn't help your argument, because if the 51A requires the circumstances of the sexual assault, that means that the therapist has to get details of the sexual assault from the complainant witness, correct?
But that means that we already know what details they did get. And so the underlying mental health records would just be
Are you
more
saying
detailed.
that, yes, so exactly, right, so the underlying mental health records would have more detail. And isn't the defendant under our case law then entitled to that?
No, Your Honor.
Well, at least entitled to pass the preliminary showing in order for defense counsel under the, confidentiality protective orders of Dwyer to look at it and then make an in-camera presentation to the judge?
No, Your Honor, because he has not established that there's actually something relevant there to help to prove or disprove an issue material to this case, which is the relevant standard that was established in Lampron-Dwyer.
But why not? If the mandatory reporter believes that he or she has the information that is necessary to make the report, it's not a leap at all to suggest that the records of that mandatory reporter contain that information.
So it's not about whether it contains that information. Here, there's no dispute that my client did disclose the sexual assault. What needs to be shown is that there's something there more than just a statement. And here's another example.
Why? I mean, I'm reading LeBron, and it says, unlike a prior case, Bourgeois, the defendant in this case alleged with particularity that the complainant's psychological records contained specific information regarding her complaint of sexual assault.
Yes, Your Honor, and there the allegations with particularity were specifically that the victim had previously made inconsistent statements. And those statements were
But
videotaped.
that's not part of the analysis. I don't see that anywhere. It's just the particularity that this complainant, this victim, did not just seek mental health treatment, which was the prior case, but that in connection with the mental health treatment, there were statements made by this victim of the specific instance of the sexual assault for which the defendant is being tried. There's nothing in here about inconsistencies in the victim's statements.
The court does clarify later that part of the reason why they're granting it is because the defense has to do with the fabrications and the prior inconsistent statements that the victim made. And another case that might be helpful is Commonwealth v. Seeley. So there was a clear indication that the victim had made a statement to the Boston Rape Crisis Center about the sexual assault. She was an undocumented victim, and so when she made the allegations or disclosed the sexual assault, the rape center referred her to counsel so that she could, where she expressed her concern that she might be deported if she disclosed the rape. And the defendant later tried to seek access to those records because he was saying that the only reason she disclosed the rape to the Boston Rape Crisis Center was to fabricate it so that she could ultimately get a U visa. This court did not allow him to get those records, even though she clearly made a statement about the sexual assault. And one more thing I would like to direct the court to is footnote 12 in Commonwealth v. Jones. There, the defendant sort of made a similar argument where he said, well, whether or not a statement is made, it doesn't matter because those records are relevant since a sexual assault happened. And the court said that even if a statement was made under footnote 12, it would render statutory privileges meaningless because presumably any time a victim speaks to a rape crisis counselor, they speak about the sexual assault. So if we're saying that any time a victim speaks to a mental health provider, here in this instance, a child, then a child would never have access to confidential treatment because a mental health provider is obligated to always create a Section 51A report. So it simply cannot be that with this Commonwealth strong public policy in favor of protecting victims of sexual assault, we would create a ruling in which children could never seek confidential mental health treatment. And that's why it's so important for the court to reject Safi's argument. I see that I'm out of time, so unless there's any other questions, we submit on our briefs. Thank you so much for your time.
Thank you. Okay, Attorney Von Flattern.
Good morning, Madam Chief Justice, members of the court. Cynthia Von Flattern, Assistant District Attorney, Northwestern District for the Commonwealth. As your honors can see, a lot of the trouble with this case started with the decision from in the trial court from the motion judge, which was very broad and based on affidavits from counsel and motions for records for treatment providers that was very vague and really merely stated that the records would be relevant because they would involve the victim's state of mind at the time of the assault and at the time of treatment, and then listed a number of mental health disorders that AR, the complainant, had, and that was reported by the mother, and particularly reporting the premenstrual dysphoric disorder. So that decision, it was clear, and I would submit that the single justice's decision memorandum was very thoughtful and went through all of the reasons why that motion judge's decision could not stand. And that decision was without prejudice, so that the attorneys could go back and make a more specific showing if they decided to. The Commonwealth submits that the attorney in the trial court, that those attorneys, that their reference to the DCF report and the police report was very vague. They never talked specifically about what was in the 51A or 51B that would support a decision like this under Lampron-Dwyer. And then for now appellate counsel to cite with a little bit more specificity to the 51A report by Rena Semperson from CSO and the 51B report, the mention from the Northeast Center for Youth and Families, is also very vague. We're not even sure what the reports were.
Does discovery include both the 51A and the 51B from the reporters, from two reporters?
Your Honor, I have gone through because again, the defense counsel did not submit it with their memorandum, and they cite we have discovery from the Commonwealth, and I have not seen a 51A from the Northeast Center for Youth and Families, so there is only that one sentence mentioned in the 51B.
Okay, so what about the CSO?
The CSO,
Records.
my brother, appellate counsel, cited to the 51A, and the Commonwealth has provided that.
Okay, that was a question. What I had.
Yes,
All right.
so the 51A is there, and I would submit that the 51A is, the way it is written, it sounds like that CSO therapist is repeating or stating what the mother has said about what AR said to her. So
There's the subsequent 51B investigation where allegedly she says that she was raped, correct?
yes, yes. So and again, no specificity, no thought that there was any inconsistency in what she has reported.
Can you help me out? In prior counsel mentioned Sealy, which I have in front of me, in LeBrod. Are those cases inconsistent, or what do we do with the fact that statements were made? Is that enough to satisfy Dwyer Lampron?
As my sister has stated, and they have looked, the counsel for AR have looked carefully at those briefs in that case, and that the record would show in those cases that there was inconsistent reports on the part of the victim there. And I think there is we have that language about...
Can I be specific? Because I think I'm doing just what Justice Gaziano is doing, which is reading Sealy and Jones while we're up on the bench. But Jones, there's no report. The footnote has the opposite. The footnote goes on to make this general point, but there's actually no report from the victim to the counselor about the sexual assault. It's the opposite. Mm-hmm. She says, and then Sealy, isn't it? It's the same thing. It's talking about. I mean, again, I'm reading it while we talk here, but isn't Sealy a case in which they speak to a lawyer, not a counselor, at the Rape Crisis Center, and we don't have a report to a counselor of a sexual assault, do we?
I think the only case with some case law, and so I think this is sort of an open area, but would be LeBrod, where the court talks about specific reports and also mentions inconsistent. I think there's one mention of inconsistent reports. So I would submit that if I mean, clearly the showing that was made in the trial court was clearly insufficient. And I would submit also that it is very important to know how broad these records were. We're talking about almost 3 years of records.
Yeah, that's a non-starter, the last one. But let me ask you on whether or not the statements are facially inconsistent. How is a judge to make that determination?
Well, if you have a motion that goes before the trial judge, I think he's in a better position to do that.
So if a trial judge gets, forget this case, so if a trial judge gets a Lampron-Dwyer motion, and it says that the complaining witness went to see a therapist, and the complaining witness described the sexual assault from the discovery, is that enough to satisfy the standard?
And I would submit, and I have talked to the trial ADA in this case, that might be sufficient for a very short period of records, not 6 months of records, not a year of records.
At least to get discovery as to what was said.
What was said, and you know, you have in all of these cases, this child has gone for a forensic interview as sane, and so the defendant knows exactly what she's saying.
The point is, though, when you get the sane, they want to match up what was said earlier to see if there were inconsistencies
Right.
or fabrications.
So that might be something, arguably, on that specific point, and that, you know, there's a realization or a recognition in that, perhaps in LeBron, that could be an issue, because of course the defendant is entitled to impeach the witness, the victim.
Chief, may I ask a question?
Yes, of course.
What I, in essence, understand your argument to be is, but correct me if I'm wrong, is that unless there's a showing of inconsistency, it hasn't been demonstrated that the information is evidentiary and relevant? Is that, am I missing something?
Well, I think if there has been a showing of inconsistency, I think
Then it meets both. Then it meets both. So if that's true, can you help me? What's your understanding, or what's your position with respect to the meaning of evidentiary within that phrase?
that the defendant would it would make something more likely than not. So if the defendant were going to use it. So again, if you have no showing about inconsistency, then I think it's hard to get to relevance. But I think you know, I think the court has always been struggling with, you know, how is the defendant going to make this showing? That's why we have Lampron-Dwyer as opposed to Fuller. But I think it is difficult to get to an evidentiary to meet the definition of evidence, and that's why you get into speculation. And there are, you know, we have decisions that will reject the defendant's showing because it is speculative. And here, you know, they even made the trial judge said, well, potential relevance is enough, should be enough. Well, that is not the standard. It's relevance. It is not potential relevance, and that maybe goes to the definition of evidentiary here.
Are you taking the position that evidentiary and relevant is the same as admissible?
No, Your Honor, because I think we do have those further steps here for counsel to show that it could be
Something less
evidence,
than
but you
right.
never get to that it's admissible.
Thank you.